Good morning, Mr. Bracken.
Good morning, Your Honors. I'm Thomas Bracken, representing the plaintiffs in this action. Approximately 2.5 years ago, this court rendered a decision.
How time flies, Mr. Bracken.
It does, particularly when
Feels
you're
like
having a good
yesterday
time
to me.
the interim. At that time, the court ruled that a regulation that the department promulgated purporting to exempt so-called landlocked tidelands from Chapter 91 jurisdiction was in excess of the department's authority, and therefore remanded the case back to the Superior Court and to DEP for further action. The defendants then moved for a stay to allow the legislature to act, because this court, in so ruling, had concluded that only the legislature could relinquish the public's rights in tidelands, and only if the legislation was explicit as to the land involved, the current use of the land, and the intended future use of the land.
So the legislature then enacted the 2007 Tidelands Act.
They did. That was after many bills were introduced and amendments and so forth, and it was finally passed and signed just before the expiration of the stay. So you're correct, Your Honor, that we're here now to address that bill, and it's the contention of the plaintiffs that the legislation does not meet the requirements set by this court and then prior cases going back to the opinions of the justices in 1981, because the current act simply gives blanket approval to relinquishing Commonwealth tidelands interests throughout the state in what the Secretary of Energy says is 40 communities involving more than 4,000 acres of land. And that, we believe, is completely contrary to what this court has set as the guidelines for relinquishing the public's interest.
Now, you know they say it has not been a complete relinquishment.
Your Honor, 2.5 years ago, my brothers were making the same argument. And I think you very clearly pointed out that by exempting these tidelands from the licensing process, the state, through the department, had effectively given up all control over the lands that were.
Didn't they create in their legislation a new regulatory review process?
Yes, that's what they say. And they continue to say that that was the intention of the legislature. But it clearly is not what the legislature wrote into this act, because if you look at sections 3 and 8 of the act that my brothers rely on, they're totally meaningless. What they call a public benefit review to be conducted by the Secretary of Energy simply calls for some sort of review that is then put into a file. But there is no mechanism for any enforcement of any public benefit determination that the Secretary might make. That's Section 8. Section 3...
What are you saying, because there's no judicial review?
No, you can have administrative.
There's no meaningful way to enforce any sort of determination. In other words, there's no document that you can enforce, because there is, and then the department has made it completely clear that the review is meaningless, because their regulation says the Secretary's public benefit determination shall not supersede, eliminate, or in any way impair the department's exercise of its powers under Chapter 91. So on the one hand, they say, yes, do the review, but at the same time the department says, but it doesn't mean anything because it doesn't affect the project. Section 3 purports to say that the developers, through the MEPA process, has to include some analysis of public benefits, but then there's a little clause, such benefits as are protected by Chapter 91. Well, Section 6 of the Act takes away any Chapter 91 protection for landlocked tidelands. So what they give in Section 3, they take away in Section 6. The determination that they purport to make under Section 8 disappears into some file, and the regulation makes clear that that is the result. So I think what we have here is an act that does not provide any meaningful alternate scheme for conducting a public benefit review. And the public benefit review is the heart of Chapter 91. And the heart of Chapter 91 is the licensing process, because as this court said, the only meaningful way to ensure that there are public benefits in the relinquished land is to subject the land to the licensing review, which requires the determination by the Secretary after a public hearing. Now,
so help me to understand. After this court issued its decision and gave the legislature the opportunity to undo it, what do you say the legislature could have done that would pass muster?
Well, I think what the legislature could have done is exactly what this court said the legislature had done in the past, and that was to be explicit as to what land was being relinquished. And this court referred to the acts that apply to both Fall River and New Bedford. The court also referred to the acts in the Back Bay and in South Boston. And then my brothers at that time came in and said, oh, no, don't say that that's right, because those acts were not explicit enough. They did not identify all the properties that were involved. So this court deferred and said, okay, and took that language out of the final decision. Now my brothers say, oh, it's perfectly fine to have no guidelines, no definitions whatsoever, simply exempt 4,000 acres of land scattered over the Commonwealth of Massachusetts in 40 communities with no guidelines, with no finding of what the current use is, with no finding that there'll be any public benefit whatsoever. The only three guidelines set forth in the Act are that it will make the land more marketable, will provide beneficial development, and will provide access to the sea. Well, if you look at the case, the project involved here, which is North Point, it doesn't do any of those things, because you've got Commonwealth tidelands on the property, which obviously the developer doesn't own, and secondly, they're fighting among themselves over who owns the property and how they can sell the property, so it certainly hasn't made the property marketable. As to the public benefits, they have evaporated. First, there was supposed to be a 5-acre central park. That's turned into holding tanks, or rather swales, I guess they call them, for stormwater overflow, unusable as a public park. The whole thing about the Green Line being relocated from Leechmere to a modern station is not going to happen. At least it's not going to happen in this project by any developer.
Is the stormwater overflow designed to accept water only from this project, or is it designed to accept water from beyond the perimeter of this project?
No, I think the water in these swales on the property will accept the water from the 30 buildings that are planned to be built there. But then the water is taken from those swales through a pipe and discharged into the Leechmere Canal, which also will discharge water from other projects. But our point is that the public benefits that were touted as justifying the project are totally illusory. And then the whole business about connecting with the Boston Harbor, well, that can't be done because the department found that the project is completely cut off from the Boston Harbor by public ways. So the three purposes that the legislature set forth are simply not applicable to this project. Now, the defendants make a great deal out of some language in the 1981 opinions of the justices, saying it's okay to sort of have a relinquishment of rights without being terribly specific. Well, if you look at Appendix A to the opinions of the justices, it's very specific. There is a map right there that shows you exactly what land is involved. There is a description of the streets that define that land. There is a commonality certainly here because it's all around the Boston waterfront. The area that's being excluded is already built up. And so as a practical matter, there's no point in reviewing whether you're going to tear down the Hancock Tower or the Prudential or uproot Back Bay. These are all the areas that the bill pertained to. And so when the justice said, well, it looks okay to do this, they were talking about a very specific, very discrete, very narrow area in one city that had already been built up. Now you go across the river to North Point, it hasn't been built up. Because of all the fighting and fighting between them, I think only 1 or 2 buildings have been built, and they have limited occupancy. They were planning to have 30 buildings and all these public benefits. But so you got on the other side of the river vacant land, which is prime for having public benefits, prime for doing something with this land. Yes, there can be condos and there can be office buildings and there can be research facilities and so forth. But in that, you should, under Chapter 91, insist that the public get some benefit out of it.
Is it your position that the legislature should identify each specific piece of land that it is attempting to address?
Not necessarily each piece of land, but the geographical areas, as the bill did that we have here, the 1981 opinions of the justices. I mean, that, it seems to me, was pretty explicit, and you can see it right here in front of you what you're talking about. But to just go with this blanket exemption that the legislature said wherever you are, whether you're in a farmland or a city or a river or a stream or a lake or whatever, it's all the same and it's all exempt and there's no public benefit review. I think, the plaintiff's position is that that is not consistent with the public trust doctrine that this court has held is applicable, and that this court in the prior Moot case held must be enforced. The argument also the Secretary of Energy makes is, this would inundate the legislature or DEP with applications if the plaintiffs are right. Well, the Secretary says there are 44,000 acres, but he doesn't say how many of these are separate parcels, how many of them are subject to development, how many of them are likely to be developed, nor does he take account of the fact that the legislature has clearly found a way to act specifically, as this court noted in Fall River and in New Bedford and in Back Bay and in South Boston. It can do the same thing in Chicopee or Springfield or wherever the land may be. Again, under the guidelines that I think the justices gave in the 1981 opinions. So the position that, and then the thing about the condition there was a condition in the 1962 license that required then the Boston and the Maine Railroad to put in underground pipes to replace the function of the filled-in Miller's River. Well, they may have done it, but they've been not maintained. They're in disuse. There's flooding in the neighborhood, sewage overflowing, and so forth. That's a condition that we say is enforceable. And the department, even in its brief, I think it's page 43, a footnote, they say that, it states on page 43, footnote 23, I quote, "The 2007 Act clearly does not abrogate or negate prior licenses." So, based on their statement and our own arguments and so forth, it's our position that this condition in the 62 license should be enforced. Since it's not being enforced and is in violation, then Commonwealth lands being involved, the land reverts back to the Commonwealth. I see the red light blinking, and so if there are no further questions, the plaintiffs urge you to reverse the decision of the Superior Court.
Thank you, Mr. Blacken. Mr. Schofield?
Thank you, Your Honor. Madam Chief Justice, may it please the Court. My name is Seth Schofield, Assistant Attorney General on behalf of the Massachusetts Department of Environmental Protection. Today I'm going to address the validity of the 2007 Tidelands Act, while Mr. Falby will address the conditions in the 1962 license for the North Point project site.
Mr. Schofield, let me just ask you this. The public trust document means something in Massachusetts.
Of course, Your Honor.
It means public, and it means trust. And in the earlier Moot case, we said you can't just say all these thousands of acres are not subject to any kind of licensing review. Right?
Excuse me, Your Honor?
You're not subject to any kind of licensing review, because one thing that the licensing does is to see whether or not the requirements of the public trust document have been met. Right?
That is
Okay.
the purpose of the licensing.
So pick any one of your 40 communities, not North Point, pick another one that's subject to this, a landlocked, subject to public trust. Pick one.
The Trinity Church or the Boston Library?
No,
Or the
outside
MIT campus?
Boston.
Outside of Boston?
Yeah, which is, that you now want to make subject to this.
I'm sorry, Your Honor, I'm not
That we now want to make
aware of a
subject to.
specific property in one of those other communities.
Well,
I can say that
neither am I. So how do I know what it is that the Commonwealth is giving up when the legislature says, okay, so you couldn't do it by regulation, we're going to de facto do it by legislation? How do I know what the Commonwealth has given up in Chicopee or Fall River or wherever the landlocked tidelands are?
Well, the answer to that question is, Your Honor, that the legislature did not give up anything in passing the 2007 Tidelands Act. What they did was issue a
Well, you
blanket
can't say they
offer-
didn't give up anything.
Well, they did give up. They exempted development on landlocked tidelands from Chapter 91's licensing
That is a
requirements.
big give up.
I'm not sure that I agree, Your Honor. I think the Act itself can be viewed as a measure of regulatory control over development on landlocked tidelands, in that it authorizes development on
What if it were not
tidelands.
landlocked tidelands?
Excuse me?
If it were not landlocked tidelands, you'd say it's not a big give up either?
If it were not landlocked tidelands, I would say it depends on what the legislature says.
Isn't this all about landlocked tidelands?
Excuse me?
Isn't this all about landlocked tidelands?
Yes, Your Honor. This case is all about landlocked
Right, but I'm
tidelands.
just saying, when you say that it's not a give up, the strictures of Chapter 91 are a mechanism by which one looks at whether, when the Commonwealth gives up the rights that the Commonwealth holds, not for itself, but for the people of Massachusetts, somebody is looking at what they are giving up. Somebody is looking to see whether or not it satisfies a public purpose, correct?
That's accurate, Your Honor. And again, I would disagree that the legislature was actually giving up public trust rights. What they were doing was exempting development on landlocked tidelands from the licensing scheme.
I
Now, it's
understand
important-
that, but what the licensing scheme does is look to see whether what they say is not giving up,
Yes, Your Honor. There
that
are
there's
two
a public benefit, that
there
there's
are
a
two,
public
I think,
benefit.
responses to that. First, it's important to recall that public trust rights in Chapter 91 are not coterminous, in that, for example, the legislature could tomorrow repeal Chapter 91. It's important to remember that that was an exercise of their lawmaking authority to regulate development on tidelands throughout the Commonwealth that first occurred in 1866.
They could repeal Chapter 91, but I don't think they could repeal Chapter 91 and then proceed simply to, in a broad brush, give to all tidelands, landlocked or not.
Well, that's the point, Your Honor. They're not giving it up. The fact of the matter is that public trust rights existed before Chapter 91, and they will exist after Chapter 91. What's important here is that in exempting landlocked tidelands from Chapter 91's licensing scheme, the legislature included special findings in the purposes that it sought to achieve. It specifically found that exempting development on landlocked tidelands would serve public purposes and achieve public benefits. Those purposes are ones that this court has held are satisfactory.
How do I know in gross? So you can take North Point and I say, how does it encourage public access to the waterfront? And you can answer that question in a procedure directed at North Point. If I go to Chicopee, how do I know that it will encourage public access to the waterfront?
Well, I think it's important to remember that some of these properties, it probably will be difficult to encourage public access. For example, if you're focusing on the Boston Public Library, it would be difficult to promote public access to the waterfront from the Boston Public Library. On the other hand, there are other purposes set forth in the Act. The other two purposes are promoting the marketability of properties and two, promoting the revitalization of landlocked tidelands. Both of those purposes will be achieved for all of landlocked tidelands. It's not, and that's the inquiry under the Act. The inquiry is not whether for a specific site there are some other, whether the T will provide benefits. The inquiry is whether the development or exempting landlocked tidelands will promote these purposes, which are redevelopment and revitalizing landlocked tidelands. Those purposes will be undoubtedly achieved at all of these properties.
Would it be acceptable for the legislature to pass a bill that says we conclude in our wisdom that it is to the public benefit that landlocked tidelands be conveyed to private owners?
I think that would be acceptable, Your Honor. It depends on what the legislature is doing, though. It depends on whether...
not parcel by parcel, just all landlocked tidelands should be conveyed to private developers, private owners.
The legislature clearly has that authority. It has always had that authority. That's what Boston Waterfront says. If the legislature wants to transfer public lands to private persons, it can do so if it satisfies the procedural requirements that are set forth in cases going back to the late 1800s and early 1900s and are set forth in the opinions of the justice's decision, what the legislature needs to do to accomplish that. What's significant here is that no place in the Act did the legislature explicitly express an intent to relinquish public trust rights in landlocked tidelands. And it would be a mistake to conclude so because the legislature set up an alternative regulatory review process to...
Is that what's in Section 3?
Yes, Your Honor. Section 3 and Section 8. Section 3, or new Section 62I of the Massachusetts Environmental Policy Act, which applies only to landlocked tidelands, requires a project proponent to describe in their environmental notification form the impacts of the project on public trust rights and the measures they propose to mitigate those rights. Section 3 then authorizes the Secretary of the Executive Office of Energy and Environmental Affairs to require the project proponent to implement measures to mitigate those impacts. Section 8 of the Act, or new Section 18B of Chapter 91, requires the Secretary to perform a public benefit determination for projects on landlocked tidelands and other tidelands, both landlocked and non-landlocked tidelands, that trigger the MEPA Environmental Impact Report requirement.
Is that separate from Section... how do those two work together?
It's
Are they independent?
They are separate requirements. The first Section 3 requirement is within MEPA, and it applies only to projects on landlocked tidelands.
But now Mr. Bracken says Well, it says that, but then if you look at it, it says, as provided in Chapter 91, and 91 exempts landlocked tideland, so it's...
Well, I think there are two answers to that. One is that the new Section 8 includes a public benefit determination for development on landlocked tidelands. So for projects that trigger the MEPA process, those projects are still protected under Chapter 91. I think it's also important not to take that language too literally. What the legislature...
What do you mean not to take it too literally?
Excuse me?
What do you mean not to take...
The legislature was, what meant by saying that, I believe, was that...
In Section 3 you're talking about?
In Section 3, where they said protected by Chapter 91. They're referring to the interests protected by Chapter 91, not necessarily the licensing scheme, which they clearly exempted from...
But that's what I was trying to get at. Forget licensing scheme. It's the interests that are protected, and every time I raise what I think is a more broad claim, you say, no, the legislature can do that, no, the legislature can do that, no, the legislature can do that, no, the legislature can do that. I mean, what are the limitations on what the meaningful limitations under the public trust doctrine, from your point of view?
Your Honor, I think those limitations are set forth in the opinions of the justices' opinion. They are the 5 requirements that the legislature be explicit about the land involved. That they
so be explicit about the land involved. I have no idea where the landlocked, what we're talking about.
Landlocked tidelands are defined in the statute. They are...
Keep going.
They're defined in the statute. They're a specific subset of tidelands. And
I mean, I know what a landlocked tideland is, but I don't know where it is, and I cannot imagine how I can anticipate whether a proposed use on that land is going to satisfy the public benefit piece of the public trust doctrine unless I have some capacity by somebody to review when that happens. It will, in fact, satisfy the public trust doctrine, which, by the way, is broader than is it environmentally sound.
I agree. There's a couple questions or points that you just raised. First, I would say that we're focused on a specific act here and what the legislature did in this case. And the legislature obviously does not hide elephants in mouse holes. They know how to explicitly affect a relinquishment if they want to, but they did not here. They used no language. Instead, they created an alternative regulatory review process. Well, we agree that review process may not catch every development on landlocked tidelands, but it will catch the most significant projects.
How do we know that? I mean, you say that, but how do we know that, and who's reviewing it? I mean, the reason why there are opinions of the justices is because somebody has asked the justices, somebody's gone through a review process to say, is the relinquishment of the public trust appropriate in this case?
Well, again, Your Honor, we don't believe there's a relinquishment. But it's important to recall that the legislature here addressed the issue.
What are the elements of the public trust that remain on this parcel of land after these plans go through?
Those lands, landlocked tidelands, as Your Honor said in the Fafard decision, remain impressed with a public trust. That is, the property owner holds title to the property subject to a condition that they must be used for a public purpose. The 2007 Tidelands Act sets forth those purposes, which are revitalization of landlocked tidelands, redevelopment, marketability of title. It's important to recall that the court's earlier decision had significant implications. It effectively subjected approximately 4,000 acres of landlocked tidelands to licensing under Chapter 91. It placed a cloud on titles. Real estate deals were placed on hold or canceled, and DEP faced the possibility of having to use its increasingly limited resources to...
I understand the parade of horribles. Believe me, I'm trying to look for a solution here too, but this seems to me to be, you can't do it under 91, so we're going to just do it anyway.
I just, in terms of the explicit regarding the land involved, I would direct Your Honors to pages, I believe it's towards the end of the opinions of the justice's decision, where the court referred to the grant of authority to the secretary to make determinations about relinquishing public trust rights in tidelands seaward of a particular line. Now, those tidelands are not defined anywhere, but the court held that that was specific enough. Now, this is equally specific enough. If you go back and look at the old older land transfer case and public purpose cases, you'll see that what was at issue in those cases was agency actions, first of all, and also agencies acting under broad grants of eminent domain authority that referred to any land or included the power to take land, parkland, to transfer it to a highway, including parks, and a whole host of, those weren't specific. What the court has said, those opinions suggest to me, is that the court wants to know that the legislature has seriously considered its action. And there can be no doubt that in this case, the legislature was aware of what it was doing. It balanced the interests versus the desirability of continued licensing under Chapter 91 versus, in light of the resources necessary to do so and the interests involved, and it decided that it was appropriate to exempt land, that it was in the public interest to exempt landlocked tidelands from Chapter 91's licensing scheme, while at the same time establishing an alternative regulatory review process.
Thank you, Mr. Schofield.
Thank you.
Mr. Falby?
May it please the Court, my name is Bruce Falby. I represent the private owners and developers. Chief Justice, to address your question about the significant give-up here, I would submit that this statute in exempting landlocked tidelands, which are now not underwater or near the water and are separated from the water by a public way, is not a significant give-up of the public trust rights of navigation, fishing, and fouling.
I understand the point, Mr. Falby.
Very good, Your Honor. I'm going to address two things. The 1962 license. The condition in the 1962 license, which was granted by the Department of Public Works, the predecessor to DEP, which required further Chapter 91 licensing upon a change in use, has been superseded by the Tidelands Act. The plaintiffs did not in their last appeal, and they don't in this appeal, contest the DEP's finding that the tidelands that are filled on the North Point project are landlocked, and nor under Section 10 of the Tidelands Act is that determination any longer reviewable. That being the case, no Chapter 91 license from DEP is now required for a change in use, notwithstanding the prior license, because now no license is required for any use, whether such use was existing before, on, or after the date of the Act.
Mr. Falby, let me ask you this. It was very clear when this legislation was going through that your client's proposed development was, if not central here, at least very much part of this legislation, correct? In the legislative history, was the existence or the status of the 1962 license discussed, raised?
I haven't seen it, Your Honor. If it was, I'm not aware of it.
Because it's anyway, it's. I mean, I hear the argument, but it's not entirely clear to me that that no change in use is subject to any license.
Certainly, the statute in sections 6 and 9 makes clear that no use of landlocked tidelands any longer requires a Chapter 91 license. And so, therefore, how can any change in use require a Chapter 91 license?
Well, it doesn't say
The point now is that DEP actually doesn't have the authority to grant a Chapter 91 license to North Point, so that to raise the question is to answer it. They also raised a condition in the 1962 license about constructing and maintaining drains underneath the Millers River, which was filled pursuant to that license. That condition was actually just a condition that drains be built. The maintenance obligation is not expressly a condition. If you read the license at page 110 of the appendix, and the plaintiffs have presented no evidence that the drains were not built or not being maintained. But in any event, whatever the status of the conditions in that prior license, they do not now require licensing for the project under Chapter 91 because the legislature has exempted the landlocked tidelands from licensing. Indeed, the private defendants believe, and also REBA and the Abstract Club believe, that the elimination of a licensing requirement for all existing and future uses necessarily ends all obligations under pre-existing licenses because those licenses are no longer required to maintain the fill or build on it. Now, the Commonwealth doesn't quite agree with that. They say that nothing in the Act abrogates or negates conditions in leases and prior licenses. You don't need to decide that, Your Honors. was perfectly clear. And
Well,
what we all
you don't think we're implicitly deciding that if we say that you don't have to, that there's no longer any enforcement mechanism for the 1962 license?
Well, I actually think you do implicitly decide it. You're
I
right.
think we do
And
decide.
we're
it.
happy with that.
Well, if we go your way.
Because it does maintain the marketability of titles. The Abstract Club makes the best point in its brief on this, that if you say that or imply that prior licenses could have some continuing validity even though licenses are no longer required, then that requires landowners to go back and research prior licenses, and it casts clouds on the title that the whole purpose of this act was to dispel. My time is up, but or maybe it's not. I have 38 seconds. Public benefits. We've heard that the North Point project in particular doesn't meet the proper public purposes of the act because the public benefits have disappeared. We agree with the Commonwealth that a parcel-by-parcel review is not required, but even if it were, North Point meets those benefits. The primary benefit is beneficial redevelopment. Obviously, taking the blighted industrial land and abandoned railroad tracks over at North Point and rebuilding them with residences and offices and condominiums and retail development and parks is beneficial. The public benefits are many. The park is there. It's required by the special permit. There are pictures of it on the web at the address in my brief. I went over and strolled through it yesterday.
But, Mr. Falby, your time is up. But let me ask you this. If it's no longer subject to any review, any revocation, any permitting, because as far as I can see, it just exempts the whole thing.
From
So-
Chapter 91.
Well, I mean, so let's say you decide to bulldoze the park.
There's a special permit, Your Honor. There's a 66-page special permit.
Okay,
That's the point. All of these landlocked tidelands are no longer near the water, but they're still subject to the community development standards. In Cambridge, they
Yeah,
need
but
a
that's
special
not the
permit.
they're not the holders of the public trust.
But the public trust doctrine protects the ancient rights of navigation, fishing, and
I
fouling. As the
understand.
opinion of the justices said in the 1981 case, it had no hesitancy in giving up those rights in landlocked tidelands or the equivalent because they don't really
I
apply
understand.
to those types of land, which are no longer near the water.
Thank you, Mr. Falby.
Thank you, Your Honor.
Take a short break.